has no flavor to it. There's no flavor into that constitution. One can read in that flavor, but I'll look at what that reading does, what violence it does to the provision of Section 178. And I was trying to develop my argument to deal with that aspect later on, the aspect of whether whether Dr. Hlophe is in fact demonstrably unfit, as it's suggested as is alleged by the applicants. And where was my contention is just let's look at the Constitution itself, because that's what binds us. This is a document that we're all bound by, and it tells us who qualifies to be nominated, to be designated by the JSC. Nobody else does that. There are two things that are completely incontrovertible about the statement I'm going to make. The first one, it is for the National Assembly to designate its members. Nobody else. Interlopers can have views about what the National Assembly has done, but it is for the National Assembly using its own rules and its own conventions and its own practices to designate who amongst them as members of the National Assembly must be designated as the 6 members that will represent the JSC. And here is the problem with the theory of the applicants. Dr. Hlophe can sit in the Portfolio Committee on Justice to decide a finding of the JSC that a judge suffers from incapacity or misconduct or incompetence. He can sit there. They don't have a problem. I hope they don't have a problem with it. He can sit. But also, under Section 177(1)(b), Dr. Hlophe is part of the National Assembly, can stand up during a debate where a judge is being, where the National Assembly is considering a resolution to remove a judge. Because remember, the JSC does not remove a judge. The JSC merely makes a finding. The body that passes the resolution for the removal of a judge is the National Assembly. Their argument, according to their theory, Dr. Hlophe can act as a member of the National Assembly, stand up, make a statement, contribute to the debate, try and influence his colleagues on where the resolution must go. Whether to remove a judge or not to remove a judge. He's competent to do that. But they say he can't sit to ask a judge or to ask a candidate for judicial office questions about their suitability. A function he has performed as a judge president before, a function he well knows very well. They say because he was found to have been found guilty of misconduct. Now, I mean, it can't apply. The theory of the applicants cannot be right where the National Assembly is considering the removal of a judge, because the removal of a judge directly impacts on Section 165(3), on 165(4). Directly impacts there. It speaks to the core of judicial independence. Nothing is as wicked as unconstitutionally removing a judge from office. It violates judicial independence to do that. Right? So, Dr. Hlophe can participate in that process of removal. But, and if he does, it would be extraordinary to come to this court and to say he should not debate, should not vote, he should not try and influence others on how to vote because he was an impeached judge, as they would like to call him. So, all I'm saying is this. It does not undermine judicial independence for Dr. Hlophe to be involved in the removal of a judge. Why does it undermine judicial independence? To perform a function that involves interviews and in the middle of 23 other members. 23 members are involved. It's the only one. who is involved. Why does it threaten judicial independence when he asks questions about the suitability of a judge? And I will also speak about his experience, how relevant is how important his experience is as a so-called impeached judge to that particular process. How necessary that experience is. So,
what you said, metric is more than enough.
What?
I thought you said metric is more than enough.
No, but when I was trying to develop my metric theory, then I got asked a question which required me to deviate a little bit from the metric theory. But let me go back to the metric theory, because that is the theory that...
I've said, I beg your pardon, but if we accept, no one seems to be arguing otherwise. He has a PhD in law. He has been a judge for this law. He has been a judge president. But since then, he has default, as it were. The issue of his qualification and experience, is it relevant for persons? The foremost question before us.
Well, it's relevant for how we interrogate rationality, the rationality of the decision that the applicants are attacking.
Before we go there, can I just ask, let me just understand the submission. Is it accepted that there's a difference between a parliamentary committee and a one, and then an appointed entity with an organ that is established in terms of the Constitution, Section 178 of the Constitution of the JSC? Is there no difference between the two?
No, with respect, the only difference is that of function. And they're both perform constitutional responsibilities.
At the moment, one performs one perform constitutional responsibilities. Then, of course, you bring the entire constitutional framework and the values and the norms that we accept as foundational to our constitutional organization. So is the submission that none of that impacts on the functions of the JSC and on the suitability of people who are appointed to the JSC?
Let me try and answer that question in the following way, Justice Posoff. First is this. The National Assembly participates in the JSC through its 6 members. So they designate 6 of their members who can participate in the JSC. And as we say, their only qualifications as far as we're concerned, take in terms of the Constitution, is that they must be members of the National Assembly. 3 of whom must be members of the opposition. That's what Section 178(1)H says. Right? So when the National Assembly is wanting to give support to the JSC, so that the JSC is able to confirm its constitutional obligations as a properly constituted body, the National Assembly must produce 6 of its members to go and sit in the JSC. And you'll see that even the JSC, the Section 178 provision, also excludes members of the National Assembly and Provincial National Council of Provinces from sitting in certain deliberations of the JSC. So there is a clear delineation of responsibility where members of the National Assembly will not be required when the JSC is considering certain aspects of its functions.
If you look at 165 form, that's the one that was referred to many times today. The organs of state must ensure the independence, impartiality, accessibility, and effectiveness of the court. Now, how does the organs of state, such as the National Assembly, do this? By appointing someone to the process that has been found to be of unquestionable.
Well, you can say it, Judge, don't worry. He's here in court, he will understand it.
He was impeached, we know that, and we know the reasons why he has been.
Yes, it was gross misconduct, yes.
So how does appointing such a person to the JSC promote the impartiality, the dignity, the effectiveness of the judicial system?
The same question one must ask. How does someone who supported the apartheid legal system, apartheid legal system, apartheid having been declared a crime against humanity. How does the National Assembly promote judicial independence? By fielding someone with that kind of history?
That's a very valid question, but that's not before us.
No. You've asked me to answer the question, how does this impeachment promote judicial independence? And I'm asking you to disabuse yourself of this notion that impeachment of a judge disqualifies them from acting responsibly.
No, but that's not really the impeachment, it's the conduct.
Which conduct?
How?
Let me address the post-impeachment conduct. He's not a judge. He's a politician. He's a politician. When he was a judge, there's only one unfortunate event that led him into trouble. And we will know if the public were told the honest truth, not this cooked up narrative that is not contained in truth. The first JSC that dealt with the allegations of misconduct against Hlophe acquitted him. The public will know that when they are being told. If the yardstick is the public, they will be told. Oh yeah, by the way, in 2008, in a very long judgment, the JSC acquitted Dr. Hlophe of the same allegations that the other JSC, the JSC of 2008, found acquitted Hlophe of the allegations of misconduct, which the next JSC.
But we have since passed that, Mr. Masuku. We have since passed there. We are where we are now, because eventually the JSC found him guilty
No, but the truth of the matter, and you must factor that in your assessment of rationality question, he was found guilty by the JSC by a majority of members. There was a disagreement. Yes. And that must tell you on the question of whether this conduct constitute gross misconduct or not. Even amongst the bodies, the body that must decide that question, there is disagreement. Even amongst the bodies, there is the body itself that must decide that question. There was disagreement on it. So what I'm saying is this: that when you try and adopt an alarmist position that suggests that this impeachment closes the door for Hlophe in life, that's an unfortunate position to adopt. It's an unfortunate position because it's not consonant with our constitution. Our constitution does not close the door for a judge who has been removed from office. And one must look at 177. 177 does not tell you that an impeached judge, a judge being removed from judicial office, for any of the three reasons, suffers, he's closed outside, and he cannot be a member of the National Assembly. And quite correctly, that we can see the light in that respect, and they do not challenge the lawfulness of his membership. Yes, Madam.
I really try not to interfere with the underlying approach, but it's one thing that I don't think we might avoid. That is the journey of the Constitutional Court in paragraph 87 of the Suitability. Because there the Constitutional Court has spoken in relation to dissemination. How to get past that in interpreting whichever provisions you refer to?
No, I mean, because
you get past that paragraph.
Yes, we have to decide the question of suitably qualified. The question of suitably qualified is simply answered by one issue. Suitably qualified is you are a member of the National Assembly. That's it. There's no any other qualifier, and that's where you get into trouble with trying to split the duties that are engaged in 178 outside membership of the National Assembly.
In essence, section 47. Am I right?
Yes.
That's all I wanted to say.
But also perhaps to gave an example of a teacher was removed from his job or her job because of an act of dishonesty 6 years ago, now a member of the National Assembly. He gets nominated by his party to be a member of the JSC. Are we going to see the same application coming up here? That this is a teacher who was removed from his position for an act of dishonesty, and therefore, why did the JSC, the National Assembly, adopt a special procedure for that teacher? We could say somebody is a carpenter who is now a member of the National Assembly, who is nominated by his party to become a member of the JSC. Are we going to find similar arguments that this person knows nothing about the JSC work and cannot be a suitable person for the JSC? Members of Parliament are not all lawyers. Members of Parliament they come from very life experiences. Some of them, as I said when I was answering just so, some of them come with a history of the past. And I'm going to open that door and say, well, because of your past, can we just find out whether you can perform a function to appoint a judge who is suitably qualified for our constitutional democracy? That is why the Constitution is very clear. That only qualification you need in order to be one of the 6 members is that you must be a member of the National Assembly. And that's when you assess the reasonableness of the lawfulness of the decision of the National Assembly. Ask yourself this question. 1781H says 6 members must be members of the National Assembly. Are these 6 members of the National Assembly? The answer is yes. Are 3 of those members of the opposition? The answer is yes. Have you complied with section 1781H? The answer is yes. But here's a difference, and this is where we might find each other with the applicants. Once a member of the National Assembly has been appointed to the JSC, which is that member of the National Assembly must perform in accordance with the role that the JSC is established for. That is the member that must go into the JSC and perform those functions that the JSC is established for. So with respect, this case, as I said, would be easy if we just we pay loyalty to the Constitution and we interpreted section 1781H in its terms. Are you a member of Parliament? Yes, I am. Are you a member of the opposition? Yes, I am actually the leader of the opposition. Do you fit in 1781H? Yes, I do. What they want, the applicants are saying when I say they, is that the question must go further than that. What is your history? Tell us. Did you support apartheid? No, I did not support apartheid. Or did you support, were you impeached as a judge? Yes, I was. Or were you fired from your job as a CEO of a reputable company? Yes, I was fired. What was it? It was corruption. No, you can't go in there. We can't do that to the work of the National Assembly. There is a presumption we must extend, and the court must extend that presumption to members of the National Assembly. That they're there to perform a constitutional function. And they will do it in accordance with their oath of office. They are not there. So, no one, a general of the former South African Defence Force, now serving in the JSC. No one will quibble that. If as long as the question that you ask is the correct one and it's consonant with the provision of the Constitution. Is he a member of the Parliament? Yes. Is he a member of the opposition? Yes. Or is she a member of Parliament? Is she a member? And if the answer is yes, then he's appointed. Don't get into the assumptions that are dragged into this matter. Assumptions that will become problematic for the relief that you are being asked to seek. What we are asking you to do is to pull the whole rug down of the procedure that was used by the National Assembly to designate the one member of the National Assembly. So what they are asking is this. As far as these 5 members are concerned, there are no questions asked about their suitability. No questions asked. Just 1 member. And it's based on what? His history. And one must ask the question, is the National Assembly not bound by the Constitution itself? Can it pass a law that says if you are a member of the judiciary and you are removed from office, you don't fall within Section 1781H? So even if your party nominates you and wants you to represent, to be designated by the National Assembly, you cannot be designated by the National Assembly, even if the majority of members of the National Assembly believe that you could add value to the process of the JSC. And exactly what does the JSC do? That should horrify the advocates. The Constitution tells us what the JSC does. One looks at 178. It says the judicial says the powers and functions assigned to it in the Constitution and national legislation. So one must go to the JSC Act to find out what the JSC does. But here is another function in 5, Section 1785. The Judicial Service Commission may advise the national government on any matter relating to the judiciary or the administration of justice. Let's just stop there. Why is it inimical to judicial independence in Section 165 for 1 member of the 6 members that are nominated or designated by the National Assembly, who happens to have been a judge before, to advise national government on any matter relating to the judiciary or the administration of justice?
They are excluded. Without the members,
independence threatened when they are excluded. So Dr. Hlophe won't sit when the National Assembly, when the JSC is advising national government on any matter related to the judiciary or the administration of justice. He won't be sitting there. And then the JSC may determine its own procedure, but decisions of the Commission must be supported by a majority of its decision. By its very nature, it presupposes that there will be, the JSC may well be split, as it was in the case of Dr. Hlophe. But the majority decision is what passed. So are we going to say that a person who dissented in the finding against Dr. Hlophe of misconduct cannot be designated, should not be designated as a member of the National Assembly by the JSC, because that person supported Dr. Hlophe's in his impeachment proceedings. It's a member of 4 members of the JSC sat together. They said, no, but this is not judicial misconduct. In fact, even considering that prior JSC had said, no, this is not judicial misconduct. I'm saying, if a person, if it's as abhorrent as is presented by these applicants, that finding against Dr. Hlophe of gross misconduct should not disqualify him. I'm asking this question. What about the person who sits in the JSC, says, no, I don't agree that his conduct is gross misconduct? Is that person qualified? Is that person acting in accordance with Section 165(4)? So it's a red. This Section 165 argument in respect of is a red herring. Completely erroneous submission, which is also supported by the FUL. Completely false submission. Here's what Dr. Hlophe says, and you'll find it in his affidavit. So here is what this false narrative that is being paraded now by FUL, unsurprisingly. And I say unsurprisingly because they've litigated against Hlophe at every point in time. So there is a program, a project. This is a project of theirs. And now joined by Corruption Watch. They are the recent recruits into attacks on Dr. Hlophe. Here's what Dr. Hlophe says. I cherish an independent judiciary and intend to work to ensure that that independence, which powered my work as a judicial officer, lasts beyond the edges. Because I was an independent judge and did not conform to traditions of control, I developed a free spirit in which I was open with my views on matters of law. I demystified what it means to be a judge of the people and from the people. I never held myself to the position of being an untouchable. I accept that judges are human too and can make errors. One of the things that I realized that I needed to do in order to perform my judicial functions effectively was to learn how to speak and write in Afrikaans, because I quickly realized that it would enable me to perform my duties with sensitivity to the culture of the Western Cape. I know of no white judge that, with intention to improve their capacity to perform judicial work, learned isiXhosa, a language of the majority of Africans in the Western Cape. When I was removed from office, I'm possibly the only judge who deliberately and intentionally learned a new language for the purpose of performing my duties. And I could conduct a full trial in Afrikaans without the need of an interpreter. To be sure, I was involved in a few controversies, some directly tied in with my passion for justice and respect for our Constitution. It was that passion for justice and respect for our Constitution that actuated me into writing the report about racism in the judiciary. Charity begins at home. Without a transformed judiciary willing to eradicate racism and sexism in all its manifestations, the broader national transformation agenda is imperiled. Merely being black and claiming to be for transformation is not in itself sufficient. A truly transforming judiciary would speak out against racism and injustice. I'm the only judge openly opposed racial offensive tendencies that bedeviled the Western Cape High Court. That is what earned me the attention of these organizations, FUL and now Corruption Watch, who today pursue me with unflinching hatred. And then he quotes his friend. What his friend says is very kind. I mean, it's the nicest thing a person can say about a man who is vilified as much as Hlophe is. I won't read it. But here's what he says in 16. While the experience of impeachment was deeply hurtful, I do not intend to wallow in the pit. I have learned to live with little, and I've learned to live with much. Much was given to me, and I intend to dedicate my last years of life serving my country with distinction and unflinching devotion. I do not expect accolades from organizations like the DA, Corruption Watch, and the FUL. I differ fundamentally with the manner in which they seek to treat me and millions of our citizens with the terror of their bigotry. I will not be reduced to an appendage of their ideological fantasies. I served my time as a judge, and I would not have chosen to bow out as it happened. I intend to continue to promote judicial independence and the integrity of the judicial office for my country's sake. If it is not for my children's sake, I will not be cowed into silence by these organizations who make it their sport to scheme, lie, and plot my downfall. That is what qualifies me to be a member of the JSC, my extensive experience and contribution to the transformation of the judiciary. This is what makes these vindictive applicants vengeful. The reality that I will continue to insist on the transformation of the judiciary, because that prospect drives fear that those they revere, who they wish to see as judges, but are not fit for our constitutional purpose of transformation, will be asked to justify where they should be accorded the honor of being judges in our constitutional democracy. They wish to protect their candidates from the scrutiny that they know I will bring in the JSC. When I was removed from office, I saw cruelty and insensitivity of officialdom. I have been there in the pit of the hell of hatred, and I know how to survive. I lost my benefits, and no official ever said to reflect whether summarily withdrawing my benefits was lawful in light of the Constitution. Okay, then perhaps I should go to a paragraph where he talks about that he will ensure that judges who are appointed, are not afraid. In paragraph 20 it says, I intend to ensure that no other judge is subjected to these unconstitutional acts of a vindictive political tyranny. I intend to ensure that judges are treated with dignity and held in high regard in return for the work that they do to ensure that we're safe from the excesses of the powerful. My new role gives me another opportunity to continue with the mission I accomplished in the Western Cape. Full transformation of the judiciary to ensure that it reflects the true identity of South Africa as a constitutional democracy. Now, if one reads that paragraph, where does it say he wants to encourage people to do wrong things? There's no way. It's a manufactured lie that he says he wants to encourage people to commit judicial misconduct, the nature of which saw him leave the bench. All he says when he talks about how he's, and remember, Dr. Hlophe has not accepted that what he did was wrong. Still challenges the constitutionality of his removal. He does not accept that a judge having a conversation in chambers with another judge is necessarily wrong. No, he's unapologetic of what happened. That's why he went full defense against in all the JSC processes, because he tells you that as a judge of significant years of experience, he has been part of conversation with other judges where they speak about judgments that they're writing. No way are you going to find the kind of allegation made by these applicants, that he says he wants to coach, he wants to promote unethical behavior. It's a complete lie. But it's unsurprising, as I said, because they have made it their mission to devalue who he is as a human being. I mean, what interest would he have to promote unethical behavior in the judiciary, having worked and sustained his life through the judiciary? But here are the paragraphs I've referred to, where he makes it very clear that this is what he intends to do with the power he has as a member of the JSC. There will be another paragraph to my recollection where he talks about the fact that he doesn't accept that a judge having a conversation with another judge necessarily brings misconduct. Yeah, no, there is somewhere where he says that, but the context he gives is not what you're being told by these applicants. It's not what you're being told by these applicants. The context is what I've just read to you. Someone who says, I'm in a new role, I accept my fate, I'm in a new role, I'm challenging this impeachment of me because I think they were wrong. And if it becomes a template of removal of judges, I'm sorry, judges will be like they will live like in a nunnery or in a monk, where there are no discussions amongst judges, where the presumption that it doesn't matter what you hear from the news about your case, which is going to be all over the news. It doesn't matter what the news say. You're focused on what matters, what you have read, what the evidence is. That presumption of judicial independence is what makes this whole case of his impeachment very dangerous for judges. Because judges talk amongst themselves. They talk not just about football and darts and karate and other things. They talk about many other things. They talk about their work. And I would not be horrified if I had Justice Ndau when you're walking into the airport tomorrow. Someone says, "Oh, I saw you on TV. Oh, you're involved in that case of the DA. Oh, okay. How is that going?" And they just have a chat with you about it. The presumption is that it doesn't matter who says what. Your wife or your husband could say the same thing. It doesn't matter who says what. If you're a judge worth his salt, you're not going to be influenced by what people say on the sidelines. That is the key of what judicial independence means. You are independent. And it means that it doesn't matter what the squealers on the side are saying about your case.
Family, this is the Family channel. Have you subscribed to the channel? If not, don't forget to like, share, and subscribe. Today, let us give our opinions as to what we have listened to about the case of Dr. John Hlophe. We understand in the case of Dr. Hlophe that he is a former judge, well qualified to be part of the delegation or part of the members that comes from Parliament to go and interrogate judges in the JSC. So we see DA taking part, trying to stop Dr. John Hlophe. The only one, we've got Brackenberg, who has done wastings, and nobody's talking about her, and many more, as the lawyer has exposed a lot in this video. Ingabe kithi senziwa ukuthi noma ngabe sinemali sibantu abamnyama, uma belungu besibona noma singaba nemali engakanani ezweni lethu, abasiboni njengabantu abaphilayo because of the past where we come from due to the apartheid system. This brings me to what Malema all the time talks about, that no matter how much money you have, in front of abalungu abamhlophe, you are just nothing to them. They don't see you as umuntu onemali or umuntu oliphezulu until somebody tells them that, oh, lona ubani umtsepe or uRamaphosa ubani. Then it's when they will start to say, oh, he's this one. Uma bangakwazi, you are just a useless metla, bangarapa icathulo zabo khona bakhipha udaba. Sibuya endabeni kaJudge Hlophe. It is so painful when you look at the case of Dr. Hlophe, well qualified. He was selected by his party to go to be part of the members of parliament that will go and grill the judges. But because he was impeached as a judge, and he's still challenging that impeachment, but DA is making it a point that he doesn't get closer to that. So this brings a lot of questions as to what is it that DA is scared of. Why are they so fighting Dr. John Hlophe? But listening to the lawyer, what the lawyer has been exposing in this video, it shows that the DA is making sure that Dr. Hlophe doesn't, because of his qualification, doesn't get close. Because most of the people that they are pushing as DA to be judges, Dr. Hlophe will expose them during the interrogation, and they feel like if he exposed them, then it will be a problem. They will not be judges to protect their privilege, because it's all about their privilege. Whatever judges they want to push, they don't want somebody who's qualified, who's going to ask them really serious questions like what Malema does. So this really shows that DA will never let it go. They will still fight and fight and fight and fight. What do you think, family, about this? Because this is exposing DA as to who they never want to let go the apartheid. Family, what do you think about this? Please drop your comment. Don't forget to like, share, and subscribe. Bravo, bravo, bravo.